Hi, everybody. We're going to go through character evidence for today. Character evidence can be kind of tough, okay, as you can see, but we are going to turn this into complete English, okay? So this is the outline that I've created, okay? We're going to go through rule 404, which is broken down to 404A and B, and we're going to go through 405A and B, okay? These rules can be fairly tough to comprehend, but like I said, we're going to go through each and every one step at a time. Okay, so let's go through Federal Rule of Evidence 404A, which is character evidence. The general rule for this rule is this: evidence of a person's character or a character trait is not admissible in court to prove that on a particular occasion that person acted in accordance with that character or character trait. Okay, we're going to go through an example, but first let's go to the next slide, which will bring out the exceptions to this rule. So the exceptions to 404A is subsection 2A and subsection 2B. Okay, we're going to go to 2A first. In criminal cases, not civil, but only in criminal cases, a defendant may offer evidence of his or her pertinent trait. And if that evidence is admitted in the court, the district attorney, the prosecutor, may offer evidence to rebut it. Okay, let's say the defendant is offering a trait to say, I'm a nice guy, right? If that's admitted, the prosecutor, right, the opposing party, may offer evidence to rebut that evidence that the defendant's a nice guy and use other evidence to say that, okay, no, he's not a nice guy. He's actually a mean person. Okay, that's 2A. Subsection 2B is this: a defendant may offer evidence of an alleged victim's pertinent trait. And if that evidence of that trait of the victim is admitted in the court, the DA, the prosecutor, may use other evidence to rebut it and offer evidence that the defendant has the same trait. So what does that mean? That really means that the defendant, let's say the defendant got into a fight with the victim. Let's say that happened, okay? The defendant is, of course, offering self-defense as a defense in that situation, correct? Therefore, the defendant will say that, hey, look, court, the victim is a violent person. He hit me across the face first. He was the first aggressor. That's why I had to use my own violent act in order to defend myself. Therefore, I'm offering you, court, evidence that the victim is a violent person. When that happens, the prosecutor can rebut that evidence and find ways to paint the victim as a non-violent person. Okay. Moreover, the prosecutor can also offer evidence that the defendant has that same trait. So in our example of self-defense, the prosecutor can offer evidence that, hey, look, court, the victim is not the first aggressor. The victim is not a violent person. The defendant is, right? And lastly, in a homicide case, only in homicide cases, okay, the defendant may offer evidence that the victim was the first aggressor, similar to our self-defense case, okay? And the prosecutor may rebut that evidence that the victim was the first aggressor by offering evidence of peacefulness that the victim has as a character trait. So our next example is this right here. As you can see, right here is Martin Luther King Jr. As we know, he advocated for most of his career for being nonviolent, for promoting peace and tranquility, okay? Let's say he's getting into an argument, a big fight with this white man, okay? The example that I'm trying to express to you guys is that the defendant's lawyer, Martin Luther King Jr., offers evidence that the defendant, MLK Jr., is a non-violent person because he's a pacifist, okay? Let's just say that happened. The prosecution can offer evidence to say that, hey, look, MLK is a violent guy because, again, according to the rule, the prosecution can rebut that evidence, okay? That's an example of the Federal Rule of Evidence 404A. So let's finally get into 404B, crimes, wrongs, and other acts, which basically breaks down into this general rule right here. Evidence of a crime a wrong, or an other act is usually not admissible to prove a person's character in order to show that on a particular occasion, that person acted in accordance with that character or trait. So that just means that, hey, the prosecution can offer evidence that the defendant committed a robbery charge in the past. To say that, hey, look, because the defendant committed a robbery charge in the past, the defendant is, of course, is going to commit another robbery. Okay, the prosecution cannot do that. That's something that this rule is really trying to promote, is you cannot bring up the defendant's past acts. So this rule is really protecting the defendant in other ways. So the only exception to 404B is that it is admissible for another purpose. So the crime that the defendant committed a robbery, say 5 years ago, would be admissible. The only way for that to be admissible is if it's for a different purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Okay, so the prosecution is trying to prove one of these things on this long list here. Then the prosecution can bring the evidence that the defendant committed a robbery 5 years ago. However, as we can see in the general rule over here in 404B, the prosecution cannot bring up a robbery the defendant committed 5 years ago. They say that, hey, look, because the defendant committed this crime 5 years ago, he acted in accordance to that trait. So that's the logic behind 404B. Okay, another example of 404B is, we all know this guy's face, right? This is Hitler, Adolf Hitler. Okay, an example of this is that Hitler is on trial for murder. The prosecutor cannot introduce evidence of Hitler's past crimes to prove that he acted in accordance to that trait. Okay, we all know about what happened to the Jews and his role that was played in that situation with the Jews, right? So if he got, if he was on trial for murder for, let's say, killing, let's say, another German soldier, let's just pretend that happened, the prosecutor cannot bring up evidence of Hitler's past crimes of killing the Jews in that trial, unless we go back to our exception here, unless the prosecutor is trying to prove Hitler's intent, his preparation, plan, knowledge, identity, absence of mistake, lack of accident, motive, opportunity, etc. So the prosecutor is using Hitler's crimes of killing the Jews to prove the following here. That'll be fine in court. That's perfectly okay. But the prosecutor cannot use Hitler's past crimes of killing the Jews to say that, okay, look, because he killed the Jews, of course he killed the German soldier. He acted in accordance to that crime. The prosecutor cannot do that at all, okay? So let's finally get into Federal Rule of Evidence 405, which is basically methods of proving character, okay? 405A is by reputation or opinion. When evidence of a person's character or character trait is admissible, only when it is admissible, it may be proved by testimony about the person's reputation or testimony in the form of an opinion, which means that if Hitler's character trait of being a violent person is admitted in the court, the opposing party may bring in testimony, a witness, to ask that witness about Hitler's reputation, or the opposing party may ask that witness that person's opinion of Hitler. On cross-examination, only on cross, not on direct, but on cross-examination alone of the character witness, the court may allow an inquiry into relevant specific instances of the person's conduct, which means that as long as the conduct that's being talked about in the cross-examination is relevant, the prosecutor, let's say, prosecuting Hitler, can ask the witness of relevant specific instances of Hitler's acts that are related to the crime. An example of 404A, example here, is that evidence of the defendant being a thief. Focus on a theft crime here, okay? Evidence of a defendant being a thief was admitted into evidence, okay? Let's say that character trait was admitted into evidence And during testimony, Tony, let's say Tony is this man sitting down here, because that's where a witness usually sits down to give testimony. This man is the lawyer, and obviously over here by the American flag is the judge. Okay, Tony right here with the glasses on talks about the defendant's reputation at work. Okay, that's an example of 404A by reputation or opinion kicking in, because upon the defendant's character trait being admitted, again being this thief, as we said over here, the opposing party may talk to the character witness, Tony, and ask about his reputation at work. That's an example of 405A. So 405B, by specific instances of conduct, can be fairly interesting. Okay, when a person's character or character trait is an essential element, that's the biggest thing of this rule. When a person's character or character trait is an essential element of the crime, let's say homicide, or a claim, let's say negligence, or defense, let's say self-defense, the character trait may also be proved by relevant specific instances of the person's conduct. Okay, what the heck does that mean? Let's go to the example in order to find out what this actually means. Okay, another example of this critical rule is that the defendant is accused of perjury. We all know when you go up to the stand and you lie, that's perjury, right? That's a crime. Okay, let's say the defendant is being charged and there's a trial. Upon cross-examination, the cross-examining attorney will ask the witness about the defendant's trait of being a liar. Okay, because again, lying on the stand is an essential element of the charge of perjury. Therefore, the cross-examining attorney may ask the witness here, the person that's circled, about the defendant's trait of being a liar. And that person can basically tell the lawyer about that person's reputation or opinion, or just simply, again, that person's specific instance of being a liar at work, let's say. So the overall conclusion of 404 and 405 is that remember the exceptions to each rule. That's the biggest thing. You can memorize the general rule, that's easy, but remembering the exceptions is the hardest thing. So memorize the exceptions and use the examples I provided in order to understand them better. Okay? Until then, I'll see you soon.